In November 2018, the Senate confirmed me as the Assistant Attorney General for the Environment and Natural Resources Division at the Justice Department. And in September of 2020, the President named me the Acting Assistant Attorney General for the Civil Division. While I remain the head of the Environment Division, I come to you today in both capacities. I'm proud to have been a two-time alumnus of the Justice Department. I was here in 2001 to 2005 as well. Prior to confirmation, I'd actually had the Chamber as a proud client. I know the Chamber to be an organization dedicated to the rule of law. Before law school, I worked for the state of Delaware doing tax policy analysis, and so I'm well aware of the kinds of issues that affect the members of the Chamber in terms of economic impacts. The Civil Division is the largest litigating component of the Justice Department, with over 1,000 lawyers spread across 6 different branches. The work of those branches is diverse, and it's critical to both defending the nation and advancing federal interests. For instance, it's in charge of the civil enforcement of the False Claims Act and the civil and criminal enforcement of consumer protection laws, and the defense of critical federal programs, the enforcement of immigration laws, and the defense of contract and tort claims. The Environment Division operates under statutes like the Clean Air Act, Clean Water Act, CERCLA, and Superfund, NEPA, and a wide variety of natural resources statutes. That division's docket split roughly equally between affirmative and defensive litigation. One subject that I feel passionate about and wanted to come to talk to you today about, and I appreciate the invitation, is about the regulatory system and its broader effort to look holistically at the impact of rules and regulatory processes. The goal, I think, is to have effective and efficient government, but limited government still. In my role in the Civil Division, I see attorneys every day who are vigorously defending government-wide efforts at regulatory reform. It would not surprise anyone viewing this virtual convocation to tell you that reducing federal regulations and reforming the ways that agencies operate have led to just as much work and more these days than litigating affirmatively in the first place, which is remarkable. Indeed, studies estimate that the aggregate total of the federal regulations that are currently in effect fall between $1.75 and $2 trillion per year, roughly equivalent to what the federal government in 2019 collected in individual and corporate tax receipts. In terms of the 114th Congress, which sat from 2015 to 2016, Congress passed 329 public laws, totaling 3,000 pages in the statutes at large. But during that same 2-year period, agencies issued more than 7,000 final rules, spanning 80,000 pages in the Federal Register. I try to do my best to avoid over-proliferation of the law, but obviously, even in my small world, I have a lot of work left to go on that. Back in 1981, President Reagan observed the need to reduce the burdens of existing and future regulations, increase agency accountability for regulatory action, provide for presidential oversight of regulatory programs, minimize duplication and conflict of regulations, and ensure well-reasoned regulations. Those same concerns have been shared by presidents from both parties, for instance, by President Clinton in EO 12866 and President Obama in EO 13563. Today, the Trump administration has made regulatory reform a top priority, not only to advance principles of good governance, but also because a better regulatory process is essential to the competitiveness of the U.S. economy globally. I want to talk about a couple of efforts in particular, starting on the civil side. First, I want to talk about the rule on rules. In December of 2019, the Department of Transportation took a comprehensive look at regulatory efforts in an attempt to clean up unnecessary regulation that was often outdated, duplicative, overly complex, etc. They understood that unnecessary and burdensome rules actually harm safety because they steer compliance energy and oversight energy away from what really matters, which, especially for an agency like the Department of Transportation, is to have safety first and foremost. This rule on rules would provide a framework for regulation across a wide range of critical areas, including airport safety, pilot training, medevac flight training, bridge inspection standards, alcohol and drug testing, fuel efficiency standards for a range of vehicles, and pipeline and hazardous safety regulation, to name just a few. I want to talk about 4 specific things that the rule on rules has accomplished. First, the rule implemented this centerpiece of this administration's efforts to make regulations more effective and efficient in EO 13771 that requires that 2 regulations be eliminated for every new regulation issued, that it impose no new net regulatory costs. And by the way, my current division successfully defended that EO in a court challenge in 2019. And the statistics bear out the seismic shift reflected in those efforts. For example, in 2017 and 2018, the number of economically significant rules dropped to just 10 per year, compared to an average of 53 per year in 2000 through 2016. Second, the rule sets out a core of rulemaking reforms that can be looked at by other agencies as best practices. It sets out very clearly a policy for rulemaking that there should be no more rules than are necessary. It specifies that rules should address market failures unless there is some compelling safety need or some statutory requirement to the contrary. It provides for more robust public participation in rulemaking through enhanced procedures for economically significant rules, including more opportunities for public comment and potential for having formal hearings with regard to material issues of fact. Third, the rule on rules addresses guidance documents in furtherance of the President's executive order called Promoting the Rule of Law through Improved Agency Guidance Documents. The Justice Department has done a lot of work in this area as well. The key reforms on guidance documents are that they be published and that they be known to all interested and affected parties, that they not impose new legal obligations in their own right, and that they not go beyond existing statutory or regulatory obligations, and that they not be used as an enforcement action, as an independent basis to impose a penalty. Lastly, fourth, the rule on rules reformed enforcement policies in furtherance of the President's other executive order entitled Promoting the Rule of Law through Transparency and Fairness in Civil Administrative Enforcement and Adjudication. The key issues DOT addressed with regard to enforcement actions are being transparent about legal requirements before doing inspections or enforcement actions, not using Chevron-type principles to expand enforcement authorities, and providing a Brady-type of procedure to provide the regulated entity with material evidence on both sides of an issue so that it can adequately defend itself. The rule also reforms the adjudication process by codifying various other procedural protections. The other thing that I wanted to mention on the civil side of my responsibilities is my work with the Department of Health and Human Services with regard to wrangling its massive set of codified regulations. The Department of Health and Human Services has undertaken significant regulatory reform efforts, including overhauling a suite of regulations to improve the care for patients, implementing pioneering use of artificial intelligence to rationalize their regulations, and these HHS reforms have already produced billions of dollars in regulatory savings. I understand concerning those positive effects at HHS that in fiscal year 2018, they accounted for over half of the regulatory savings of the entire federal government of $12 billion. One effort has involved looking to the 1980 Regulatory Reform Act, which was one of the earliest attempts to balance social goals and federal regulation with the needs and capabilities of small business. The act has saved small business hundreds of billions of dollars over the decades by seeking to ensure that the federal government regulates at a scale that is appropriate to the size of smaller businesses and to their resources. In 2019, HHS issued a proposed rule that informed the public that certain regulatory requirements in the Uniform Administrative Requirements, Cost Principles, and Audit Requirements for HHS awards would not be enforced because of serious concerns under the RFA. One impressive thing that I learned as well is that HHS has put their massive set of regulations under the scrutiny of an artificial intelligence process that used machine learning to identify inefficiencies. In a first pass, HHS found broken references, regulations addressing laws that no longer exist, orphan regulations that no component was implementing, and overly burdensome paperwork requirements. That first pass found 1,200 of these types of problems, and now the task of efficiently fixing those 1,200 problems, which spread across a variety of rulemakings, falls to HHS. In the remaining part of my remarks, I'll turn to the environmental side of the House and reg reform there. Three particular things that I wanted to highlight for you. The first relates to supplemental environmental projects, or SEPs. Citizen suit litigation is the second, and the last one is revision of the foundational National Environmental Policy Act, or NEPA, the regulations under NEPA. On March 12, 2020, turning to the first topic of SEPs, I issued the latest in a series of legal memoranda about supplemental environmental projects. Through that action, the Environment Division and EPA will no longer enter into civil environmental settlements with private defendants that include SEPs. SEPs are projects or activities that go beyond what could legally be required of a defendant in court. And they're designed to secure benefits for the public health or for the environment. But by definition, SEPs are not penalties payable to the federal treasury. They're not restitution to a harmed party, and they're not a form of action that's intended to undo or remediate environmental harm. Let me give you a little bit more background. Most federal actions for failure to comply with the environmental laws are resolved through settlement, and violation of the environmental laws also often results in civil monetary penalties against the violator. Settlements usually stipulate the amount of the penalty, and then EPA and DOJ determine the penalty by considering a wide variety of factors. And starting roughly since the Clinton administration, those kinds of policies have been in place. And since 1984, EPA had some form of policy authorizing SEPs in place. But the fundamental problem with SEPs is that an alleged violator will pay a lower civil penalty. And indeed, EPA had established in prior administrations an exchange rate for those penalties by voluntarily agreeing to undertake a SEP. So essentially, there was a trade-off between a SEP and a monetary fine, but that creates a diversion of monies away from the Treasury and away from congressional control as to how to spend that money to support special projects that EPA, sometimes with DOJ input, would select. And that would favor very particularized interests and violate the law. To protect the power of the purse, Congress had passed several laws, such as the Miscellaneous Receipts Act and the Anti-Deficiency Act. The point of those statutes is that the accounts receivable of the United States are to be paid into the Treasury and must go out only as Congress directs. Congress has not spoken with the clear intent to authorize the executive branch to use SEPs, except in rare cases. And of course, in those situations, the memos for policy that I put out banning SEPs, we would instead follow a contrary statute. But again, those are rare. The second reform topic I wanted to talk to you about in the environmental space is citizen suits. Citizen suit provisions are found in many environmental statutes and generally allow private citizens to enforce federal law. The early environmental citizen suit provisions were inspired and modeled after provisions in the Civil Rights Acts. Sometimes those suits live up to the goals set by Congress. With the right enforcement, however, comes the responsibility to enforce in a manner that is truly public regarding and not designed for personal enrichment. Let me provide an example. Congress's purpose in enacting the Clean Water Act was essentially to prohibit the discharge, eventually over time, of any pollutant into any water body. And thus, any unpermitted discharge of pollutants would be something that could form the basis for a citizen suit. A citizen suit cannot, however, use the leverage created by that claim for personal enrichment. A Clean Water Act penalty subjects defendants to significant penalties, and in many instances, the penalties are compounded per violation per day, subjecting sometimes defendants to millions or hundreds of millions of dollars in penalties. Where Congress directs that penalties be dispersed in a particular manner, its intent controls. So while I applaud appropriate enforcement by citizen suits, I'm concerned that these tools can be and have been abused. Another example for the abuse can be seen in the potential for using SEPs in citizen suits. So it compounds the problems of SEPs and the problems of citizen suits in one. And ENRD has in particular been grappling with that problem in a particular case in Michigan. That case, United States versus DTE Energy Corporation, was litigated for over a decade. After 2 appeals and an unsuccessful attempt by DTE to obtain a petition for a writ of certiorari, the United States, DTE, and intervener Sierra Club negotiated to a proposed consent decree. Sierra Club, however, wanted more, and they wanted different relief as well, including the requirement that DTE undertake 2 completely open-ended mitigation projects. One of these projects will require DTE to expend at least $2 million on unspecified SEPs in Southwest Detroit to be proposed by a 5-member committee comprised of representatives of DTE, an academic, and 3 members of the community selected with input from the Sierra Club. The process that's a process that we think is alien to proper federal enforcement. The second project would have required DTE to perform an unspecified energy sector project at a Detroit community center. The fundamental point that I want to underscore about an action like this is to stress that the private attorney general that a citizen actor is supposed to be performing as is not designed to allow such a group to pursue relief if the United States has decided to forego. Otherwise, our ability to settle cases would be undermined. In the consent decree, the United States negotiated deadlines to limit the pollution from multiple DTE sources, a payment of $1.8 million in penalties, and performance of a $5.5 million mitigation project, among other relief. We don't think that citizen enforcement should be able to go beyond that level of enforcement that constitutional officers selected. The last topic that I wanted to cover with you in the environmental area was reform of the NEPA regulations by the Council on Environmental Quality. The administration has pioneered several reforms, but I think NEPA reform in particular is important for the business community. That act was signed into law in 1970. It created CEQ. Regulations were issued by CEQ in 1978, and with one small exception, the regulations have not been changed until July of this year. So it's a remarkably overdue set of reforms. As many of you may have experienced in the business community, if you have a project with a nexus to the federal government, NEPA compliance has resulted in unintended and unexpected consequences in the agriculture sector, in small business, energy development, and infrastructure projects. Those consequences include, but by no means are limited to, increased costs, increased delays, and other kinds of burdens, all of which avoid getting needed public benefits out to the general public. For example, environmental impact statements, or EISs, for federal highway projects often average over 7 years to complete. And the federal government, these reviews, these EISs, typically average 4.5 years to review, and they run typically, or on average, 600 pages. The unintended consequences of that for the national economy have been staggering. And these burdens have persisted for decades despite pragmatic interpretations of the act from the Supreme Court. For example, in the public citizen case from 2004, the court held that in NEPA, CEQ's regulations should be interpreted to provide a rule of reason kind of analysis to determine to what extent and when to prepare an EIS. Notwithstanding the public citizen case and other precedents like it, even projects with no significant environmental effects can take many months or years to complete. Recognizing this broken process, CEQ acted to reform the regulations for the first time in 40 years, as I noted. There are a number of reforms. For instance, there are changes that are intended to eliminate delays or streamline them, to reduce compliance costs, to reduce the time it takes to produce EISs to 2 years, and to specify presumptive page limits. The regulations also specify that effects that should be considered should only be ones that are reasonably foreseeable and that have a reasonably close causal connection to the proposed action. Similarly, under the amended regulations, federal agencies don't need to prepare EISs in connection with non-discretionary decisions or non-federal projects with only minimal federal funding. The amendments likewise clarify the meaning of regulations that have not been interpreted in a consistent fashion by the courts to try to harmonize those interpretations. These long overdue regulatory reforms will benefit the environment and our national economy by accelerating environmental reviews and modernizing NEPA regulations for the 21st century. In closing, I'd like to note that the Environment and Natural Resources Division is now defending 5 different challenges to those regulations, and we look forward to continuing to defend them. So I hope that that's given you some sense of our regulatory reform priorities at the Justice Department in probably the two most significant litigating divisions that deal with regulations imposing significant costs on the national economy. And I thank you for the invitation to speak to you today.